Okay, CC students, the next topic we're going to talk about is direct examination. Now, this is part 2 of our direct examination videos. The first part was the overview, the purpose of direct examination. This is part 2. We talk about how to conduct direct examination. One thing I want to point out is that direct examination of any witness should start strong and finish strong. Now, perhaps you have a witness that has some problems with their credibility. Maybe they have a criminal conviction, or maybe there's something they've done wrong, and this is part of your mock trial packet. You want to sandwich that between strong facts in the beginning and strong facts at the end. You don't want to start with that, and you don't want to end their testimony with that. You want to package that in the middle. Just a point I wanted to bring out. So there's 4 parts of direct examination to be effective. Part 1. This is where we introduce and humanize the witness. This is where we're going to make the jurors like, respect, or identify with the witness. So why should they like them? Why should they believe them? Do they have some specific training? If your witness is an expert, and we'll do a video about expert testimony, but if they're an expert, what is their education? What is their training? What is their background? If they're a police officer, how long have they been a police officer? Where did they go to school? This is connecting the jury to the witness, okay? Then the next step, after we've connected the jury to the witness, now we need to connect the witness to the case. See, the first part is getting the jury to connect with the witness. The next step is to make the witness connected to the case. Why is this witness here? What is their connection to the case? And we're going to insert them right into the case. Okay, maybe they were a person who saw an eyewitness to a crime or something to that effect. You're inserting them into the case and telling the jury why they're connected to the case. The next thing you're going to do is you're going to have the witness describe the scene. Remember, this is like a play that we're putting on, and the fact that we have to paint the picture. Our scenery is the testimony and exhibits that we're going to offer. But this is a reenactment of what occurred, right? And this is the fact that we are going to bring the jurors back to an event that occurred previously. We can't actually reenact it if it's a murder case and murder someone so they can watch it. But we can testify in a way that through our words and our exhibits that we are going to have them describe the scene. And the witness's words are our scenery. Our charts and our diagrams are our props. Okay, this is what we're doing. We're having them describe the scene. And another thing we're going to do is we're going to let the witness tell their story. We're going to get out of their way and let them tell the story that they're here to, because the focus is always on the witness, not on the attorney. So that's our 4 parts of direct examination. Now, how do we perform direct examination? Well, like I said, the focus is on the witness, not the lawyer. So that's the first thing that you want to know. This is not about you as playing the role of the attorney, even though you're going to do a really good job and you're going to ask questions. Your job is to guide the testimony. You're supposed to guide the witness through their testimony by asking questions to help elicit responses. If you have a police officer who responded to a scene, your job is to help them tell all the information that you want to get out of that witness that helps prove the legal elements of your case and also the factual theory of your case. And it's your responsibility as the attorney to bring out that testimony in the form of your questions. You're going to guide their testimony. And a part of taking the focus off yourself and putting it on the witness is your positioning in the courtroom. You position yourself so that you are, if you can move the podium, you want to move it away from the front of the jury and away from the jury so that the jury is between you and the witness. And that's important because you want to be able to hear the witness, and if you can hear the witness and you're past the last juror, you know the jury can hear it. But more importantly is the jury is not distracted by you. You're focusing on the witness, and the jury is focusing on the witness. So you want to position yourself so you can hear. Your attention is on the witness. Your eyes are on the witness. Why are your eyes on the witness? Well, you want to watch them, but also if the jury looks away from the witness after the witness gives an answer, you're looking at the witness while you ask your next question. Guess where the jury's attention is going to go? Off of you, back onto the witness. So you already know what you're going to ask. after the witness has answered their question. How do you know that? Well, that's through preparation, but most importantly, as you're putting your attention on the witness, you're going to listen to their answers. What are they going to say? And this is where it's going to get exciting, because you're going to think to yourself, as the witness is answering the questions, did they answer correctly? You know what you want the witness to say. Did they say what you wanted them to say? Did they answer correctly? If not, you ask a follow-up question because you know what the answer should be. So you're going to ask a follow-up question to pull that information out of the witness. Now, we don't ask leading questions in direct examination. So here's an example of a leading question. Officer, you saw the murder, didn't you? That's clearly leading, because that basically the answer is in the question. The answer is yes, I saw the murder. So we're saying, you saw the murder, didn't you? That's leading. Another question that is close to leading but not as bad is, officer, did you see the murder? That's not quite leading, but that can be close to leading. Here's a really perfect direct examination question. Officer, what did you see? Answer, the murder. See how that happened? Leading. Officer, you saw the murder, didn't you? That's clearly leading. Officer, did you see the murder? That's closer, but it can cause problems. But really, the best way to say is, officer, what did you see? Now, because you've prepped with your witness, and when you ask them the question of, officer, what did you see? They already know that you want them to say, I saw the murder. Okay? So that's the key there. Not leading. Here's a way to avoid asking leading questions. Here's some tips for you. If your question starts with who, what, when, where, why, how, describe or explain, you're pretty safe that you will not be asking a leading question. Let me go over that again. If your question starts with who, what, when, where, why, how, describe or explain, then you're pretty safe that you're not asking leading questions. So when we're asking questions, we want our questions to be short, specific questions with only one point in them. That's the key. Because it gets very confusing when we're asking multiple point questions, and it's confusing for the witness and it's confusing for the jury. So we want to ask short, specific questions. Mrs. Klepper always says, how do you eat an elephant? One bite at a time. How do you give direct examination? One question at a time. And there's two ways we ask questions. We ask broad questions. I would say that this is our introduction, right? In our introduction, we're asking broad questions. Officer, tell me about yourself. And we ask broad questions first, and then at key points, we move to narrow questions. Let me give you an example. If you have a case where the police officer, you say to this, let me ask this question like this. Officer, were you working as a police officer on February 14th, 2019? Yes. Did you receive a call to respond to 1 First Street for a shooting? Yes. What did you see? All right. So those are broad questions. And then his response to my last question was, what did you see? Was, I saw the defendant standing over the dead body with a smoking gun. Okay. Now, I want to narrow that down. He just gave me this broad statement because I called for it with a broad question. What did you see? So now I'm going to pace his testimony through my questions because I'm guiding him, and I'm going to ask some narrow points. This is my pacing, and these are key points. So in that case, I'm going to say, officer, where was the defendant standing when you saw him with the smoking gun? What hand was the gun in? What expression did he have on his face? What did he say, if anything? What did the gun look like? What color was the gun? Do you see how I took that and I went narrow, boom, boom? He said a very broad statement. I saw the defendant standing over the dead person with a gun. But now I've broken that down in very narrow points because that's a key point to my case that I want to present to the jury. So I'm pacing this, I'm going broad, and then when I get to the key points, my key points are obviously I want the officer to testify to what the defendant was looking like, what did he say, what hand he had the gun on, how he was standing. All of those things are very narrow questions to elicit very narrow information, and that's bringing the jury's attention that this is a really important part. Broad questions to narrow questions. And we use narrow questions on key points. Another thing that's a good thing to use for direct examination is directional signs or signals. I want to say, this is both for the witness and the jury. Officer, I want to talk about what happened on February 14th, 2019. Were you working as a police officer? Look, everybody in the courtroom, including the officer, knows we're going to talk about February 14th, 2019. And if you have a witness who gives a lot of information, you could say things like, officer, you just gave me a lot of information about the defendant standing there with his gun. I want to ask you some specific questions about how the defendant was standing. Okay? Boom. Now I'm giving him direction. These are guideposts. Other thing too is a good thing to do is in your phrasing of your questions, along with the lead-ins, the who, what, when, where, why, how. Another thing you can use is tell the jury, tell us. You're reminding the witness that they're talking to the jury. That's their point of being here. And most importantly, use charts and diagrams wherever possible. If you're having them describe the scene, and they're the only one that's been there, but they have a chart that they've created or a diagram of what the scene looked like, get that witness out of the witness stand, have them come down in front of the jury, have them point to different parts as they testify. It serves two purposes. Number one, it's a reinforcement of their testimony with an exhibit, and it plants that in the mind of the jury of what occurred. But the second part of that is it helps the witness testify, because now they don't have to remember everything off the top of their head. They have a visual aid. The same thing I'm doing with these presentations for all of you. This is my chart. This is my diagram. This is how I'm moving through it all. All these little things help me remember what I want to tell you. Well, if you have little things in a diagram that helps your witness remind them of what they want to tell the jury, that helps prove your case. So remember, direct questions, not leading questions on direct examination. Everything's tied back to our theory, to our theme, to elements of our case, to our factual elements, purpose of our questions, tensions off the witness or off the attorney onto the witness, and our questions should be like who, what, when, where, why, how, describe. Broad questions on major points, broad questions on overall points, narrow questions on our major points. Sorry if I confused you on that. Good luck to you, and we'll see you in the next video.